Hi there, welcome once again. The Disability Law Show. John Scholes alongside. Beside me, James Fireman, going to be answering all your questions today. You want to reach out, help@disabilityrights.ca. We'll put all this information on the screen, of course, as we go along. 1-855-821-5900. Among other things today, invisible illnesses and disability claims. What does it mean? Well, we'll find out. We'll drill down into that a little later on in the show. But James, good to see you, pal. What do you have for the week that was?
Well, today I want to talk about a case I recently had at mediation, and it's a particularly interesting story. So my client was a professional, and she had some mental health issues, and she applied for long-term disability and was approved. She was approved initially, and she was on disability for about a year or so. And then her insurer sent her for an IME, an independent medical evaluation with a psychiatrist. And the psychiatrist assessed her and determined that she was not ready to go back to work. She was still disabled from work. Despite this, it was very clear, despite this clear opinion from the insurer's own hired psychiatrist, they decided to cut off her benefit. Now, it would be bad enough if they simply just ignored what their own doctor was telling them, but they went a step further. When they wrote to my client telling her that her benefits were being cut off, they told her that the reason they were being cut off was because the psychiatrist who had said that she wasn't able to return to work had said the exact opposite. They told her that the psychiatrist said she wasn't disabled and she could return to work. In short, they lied about it. So she waited a while before she came to us, as it turns out. Thankfully, she did it in time so that there wasn't a limitation issue. And so it was about a year before she retained our services. And during that time, she'd actually started to get a bit better. And we booked a mediation earlier this year. But a few months before the mediation, she was in fact feeling so much better that she wrote to her employer and told them that she was ready to go back to work. We had this ongoing lawsuit with her insurance company, but she was feeling better. And so she wrote to her employer to say, I am ready to go back to work. Now, in a normal situation, if I am going to a mediation and I have a client who has written to their employer at some point before the mediation and said, I'm okay to go back to work, I know I'm not going to get my client any benefits beyond the date that they told their employer they're ready to go back to work. That's just common sense. In this particular case, though, that's not what happened. Not only did the insurance company pay my client the benefits up to the date of mediation, so 3 months beyond when she had already told her employer she was ready to go back to work, but they paid her an additional amount equal to about 3.5 years worth of benefits. Now, why did they do that in this particular case? Well, they didn't come out and tell me, so I can't tell you for sure why they did it, but I got a pretty good idea. They knew that if they didn't settle this case, if this case was one of those rare cases that winds up in court and a judge had to determine the outcome, a judge probably would have only awarded her benefits up to when she had said she's ready to return to work. But the judge would have also awarded punitive damages for the conduct of the insurance company, for lying to their insured. They can't do that. You cannot lie to your insured. If you're an insurance company, you have a duty of good faith. And it was pretty clear in this case that they did not abide by their duty of good faith, and they knew it. And they knew it. And that's really the only reason I can think of why they would be willing to pay almost 4 years beyond the date when my client had said that she was ready to return to work. Now, are punitive damages going to be available in every case? Of course not. It's not simply a matter of whether the insurance company got the decision right or wrong. Insurance companies are entitled to make mistakes, and as long as those mistakes are in good faith, as long as their process is fundamentally fair, if they happen to arrive at a decision that a court disagrees with, well, sure, they'll have to pay the benefits, but there won't be punitive damages on top of it.
Right.
But in a case like this, where the insurance company has obviously not acted fairly, has obviously not acted in good faith, they know very well that a court is likely to award punitive damages. And they want to avoid that at all costs. Because it's not just about the money that they have to pay. It's not just about the benefits and the money that they're awarded to pay in punitive damages. But LTD cases are pretty rare. It's pretty rare that an LTD case goes to court. And when there's an LTD case that goes to court, it tends to get publicity. And that is especially true if there's an award of punitive damages. And so they know that a case like that is going to not only cost them money, but it's going to create an awful lot of bad publicity. So they want to avoid it at all costs, and that was really apparent in the way that this case resolved.
What are their Would your client been able to, after the IME and got the result, like, no, our doctor said you're fine, which was a lie, could she not get a copy of that way back when and said, no, it says right here that I'm not supposed to be returning to work. Your doctor said so.
Sometimes they're willing to give a copy of that, and sometimes they're not. More often than not, they won't do it unless you have already started litigation. They might answer your question vaguely. Typically, they're not going to be terribly responsive to coughing up those documents, even though they ought to.
Now, that 3.5, almost 4 years of benefit, which is an astronomical number from what it sounds like, will that be affected anyway by her returning to work?
No. It was free and clear. So. And to be clear, she hasn't actually been able to return to work. There are some restrictions that she has, and that's a whole other issue. But the reality is, if and when she does return to work, and she may well do so in the near future, if that does happen, there is no impact in her settlement. That is money that she has in her pocket, that she has free and clear as a result of the settlement. And yeah.
Nice. I want to send you to a website anytime, even during the show. You can check this out, pocketemploymentlawyer.ca. Yes, it says employment lawyer, but James Fireman, there's an employment side to it because they always, or quite often, go hand in hand. And there's lots of employment law information on the website, but there's also a very robust section on disability law as well, pocketemploymentlawyer.ca. Anytime you can ask questions there. It's absolutely free. It's anonymous, and there's contact there as well, the top right of the website. So check it out. James, want to move on to our first email of the day. Again, help@disabilityrights.ca is the way you can reach out to James or a member of his team and ask your questions. First one today is from Roger. Roger says, I've been receiving LTD since 2019 while waiting for surgery on my hip. Due to COVID, my surgery date keeps getting bumped. Recently, I received a letter from my insurance provider stating I'm not totally disabled and can return to work. If it were not for the pandemic, I would have had my surgery already. Do I have any rights since it's all completely out of my control?
Okay, well, a few things. First of all, if your insurer is cutting off your benefits because your surgery's been bumped, that's obviously not something they're entitled to do. You're quite right. You don't have control over when you're scheduled for surgery, particularly in the middle of the pandemic. But I'm actually not 100% sure that that's what's happening here. And I would need to dig in on the file a little bit to determine what is happening. My suspicion is that based on when Roger started getting his LTD benefits, he's coming up on that 2-year mark. So this is probably a function of what we call the change of definition. During the first 2 years that you're entitled to receive benefits, the test is whether you have a disability that prevents you from returning to your own occupation. After 2 years, it gets a little bit harder, and it becomes whether you have a disability that prevents you from doing any occupation you're qualified for by training, education, or experience. And so what I don't know here is what Roger's pre-disability occupation was. If his pre-disability occupation had some physical component to it, even if it wasn't a heavy physical job, but if it was something that required him to be on his feet some time during the day for some amount of time, then probably he's not able to do that because of his hip issue. And then the question becomes, after 2 years, is there another job that he would be qualified for that would be sedentary? So one, you'd have to find out, does his medical condition prevent him from doing a sedentary job? If he's got a hip issue, does that prevent him from sitting for a prolonged period of time? Possibly. That's certainly not something that I can comment on one way or the other. That's something that's going to be left to his treating doctors for commentary. But if he is medically able to do a sedentary job, then the question is, does he have qualifications? Does he have the education, the training, or the experience to allow him to be qualified to do a sedentary job that would pay him a commensurate income? And so it may well be that the insurer has seen that he's at the 2-year mark and has said, okay, well, there's another job that you're medically capable and qualified to do. That's possible. On the other hand, if before Roger was disabled, his occupation was sedentary, was something that required him to be seated, and he can't do that because of his disability, well, nothing's changed. And so if that's the case, I can't really see a scenario where the insurer would be entitled to cut him off just because it's the change of definition. He couldn't do the sedentary job for the first 2 years. Why would he be able to do it now, especially while he's waiting for surgery?
You know, you slipped in there that phrase commensurate income again. I want to go over that one more time. Like we try to bring it in every couple of weeks just so people don't know what that means as far as this case or any other. What does that mean?
So that's a great question. So at the 2-year mark, when we have this change of definition and the test it becomes whether you have a disability that prevents you from doing any occupation that you're qualified for, that doesn't mean that if you are, an executive, that all of a sudden, if you're able to do a minimum wage job, you're no longer entitled to benefits. In order for the insurer to be able to say that you are not entitled to benefits, they have to show that you're able to do some occupation that will pay you commensurate income. So you have to be medically fit and qualified to do a job that's going to pay you something that is in the vicinity of what you were making before. And what the courts have determined is it's somewhere in the range of 60 to 65%, which is usually pretty close to the amount that you're getting in disability benefits. So if you want a a soft rule of thumb, something that you can just look at and say, am I able to make this or not? Look at what you're getting in monthly benefits or what you're entitled to. And more often than not, if you are able to replace what you're getting in benefits with income, if you're able to work in a job that would replace that amount of money, you're probably not going to be entitled to benefits. If you're not, you probably are.
All right, as mentioned off the top, we'll get to it after a short break. Invisible illnesses and disability claims. That is coming up, but first I'll give you some contact information as we take a short one now. 1-855-821-5900. Email address we use, like Roger's there, help@disabilityrights.ca. It's a disability law show. We're coming right back. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. Okay, welcome back. Thanks for hanging in. Disability Law Show. James Fireman here to answer all the questions, emails, and otherwise. You want to reach out to James anytime. Couple different ways. 1-855-821-5900. Put you in touch with himself or a member of his crew. I also want to mention mydisabilityquestions.com. Great website. A place for you to ask your questions. And the best part about it is has a searchable database, which means you can see if your question has been asked by someone else and answered. If not, a member of James' team will get to it. mydisabilityquestions.com. But invisible illnesses. Let's get this chat happening, James. What is an invisible illness?
So an invisible illness is something that doesn't show up on an X-ray or medical imaging, a CT scan, MRI. So here we're talking about, the first thing that comes to mind are mental health issues, emotional and psychological issues. That's just not something that you're going to be able to show that you objectively have or don't have. Then we have things like cognitive issues. Now, sometimes you can have a brain injury and that will show up on medical imaging, but there are other cognitive issues that can be the result of things that will not show up on anything objective. And so that would be an invisible illness as well. And then you can have physical disabilities that are quote unquote invisible too. So yes, things like broken bones are going to show up on x-rays, but there are a lot of physical issues that involve, the small fibers of the muscles and the joints that isn't going to show up on medical imaging, but is still there and still is legitimate. Or if it would show up, it would only show up if you had access to the absolute top-end medical machinery. If you're at the Mayo Clinic, maybe you can detect it, but for most people, it's simply not there. The reality is that medical science advances over time. So, what we're able to determine now versus 100 years ago is quite different than it was 50 years ago, even 10 years ago. It's quite different than what it is now. And so over time, we're able to see these illnesses more objectively than we were able to in the past. But whether we can see them objectively through medical imaging or some other method, doesn't mean that they are or are not real. If you have the symptoms, they're real and you're entitled to be compensated.
So why do a lot of insurers a lot of the time deny these claims for invisible injuries?
Well, it's a lot more difficult to argue with. So if you have something that is not objectively provable, the insurer will use that. They'll leverage that against you. And so they'll say, well, there's no objective proof that you have this. There are no tests that show that you have a condition that should lead to those symptoms. Here's the problem with that, though, John. Cases like this have been before the courts many, many times. And the courts have said repeatedly that that is not a valid basis to deny a claim. The Supreme Court of Canada has made it very clear that the focus of the analysis has to be on the symptoms, not the diagnosis. And in LTD cases, specifically in LTD cases, insurers that have denied claims based on a lack of objective evidence have not only been ordered to pay the benefits that they ought to have paid, but have also been ordered to pay punitive damages because they know they're not entitled to deny claims on that basis. They know that if someone legitimately suffering from symptoms, even if there isn't objective medical proof, that does not mean they aren't suffering. That doesn't mean they don't have a disability that is preventing them from being able to work.
So now I'm watching the show today, or I've heard your radio show as well, that we do that every week, and I'm thinking, okay, that I fit right into that category. That's in my wheelhouse. I've got an invisible injury. What do I do if I've been denied or cut off from my insurance company?
Well, that is the easy part, John. You give us a call, and we can talk. It is as simple as that. And the reality is we give free consultations if you have any questions about disability insurance, whether you are going to apply for your benefits, whether you have already applied and you're waiting to find out, whether you are getting your benefits, or if you've been cut off or denied your benefits. If you have questions, you give us a call. You don't have to give a credit card number. You don't have to pay for the consultation. It is 100% free. We're happy to talk to you. If you have any questions, we will provide you with the answers. And if you have a legitimate disability claim, if we review your case and we say there's something there, you can retain us if you choose to, well, then you have that option. And if you would like to retain our services, then we go ahead with that. But you're under no obligation by calling us to retain us. You don't have to pay anything for the consult. And the other thing I would add is if you have a loved one or a family member or a friend who is in this type of situation, oftentimes they're not ready to call themselves. They find it too difficult, especially people who are suffering from mental health issues or cognitive issues. They may just find it very difficult to take that first step. You can absolutely call and get information for them. You don't have to reveal any personal details, so you don't have to identify who they are, but you can certainly call and get information for a family member or for a friend and just help them in that process. And if they want to take it further, they can.
So if you've been denied or you've been cut off, and I love asking you this question, it's like slowly pulling the pin on the grenade every time I do, but should you appeal?
No, you should not appeal, John. No. So if this is your first time watching the show, let me tell you what. The appeal process is not something that you are going to find in your insurance policy. Most people are a little bit surprised by that. Most people think that when you get denied and they see that there is this option to appeal the denial or cutting off of your benefits, that that's something that the insurer is required to do. They're not. Now, you might be thinking, oh, they're not required to give me an appeal, but they are anyway. How nice of them. Well, there's a reason why they're doing it, John. The reason that every insurance company is going to offer an appeal to anyone who has been cut off or denied benefits isn't because they're required to, it's because it's in the insurance company's best interest. Because when you appeal, all that happens, all that's really happening is you're asking the insurance company, pretty please, would you reconsider your decision? And you have to remember who these insurance companies are. These are corporations, very large corporations with many shareholders, and the corporation has a duty to their shareholders to make profits as large as they can. So be it. But in doing that, you have to understand what their interest is, what their motivation is. Their motivation is to make profits, and insurance companies make profits by paying less money to their insurers, by paying less in benefits, by cutting people off and denying claims. That's what their incentive. And if they have already found a justification to cut off your claim or to deny your benefits, it's going to be very difficult to get them to change their mind. They're only going to do that if you force their hand. And the only way to force their hand is to take control away from them. You can't do that when you appeal. When you appeal, you're allowing your insurance company to continue to maintain control. The only way to take control away from them is by starting a legal claim, by starting a claim in the court process and making sure that the insurance company has to come to the table and has to act reasonably, because if they don't, they wind up in front of a judge, and they do not want that.
And it's a fact as well that if you do end up appealing, going forth and trying it, and you get denied again, they'll give you another chance to appeal again and waste more time, right?
Oh, sure. And I've seen cases. I had a client in the last year who appealed, I think, 7 times before they came to me. It was 6 or 7 times before they came to me, and it was absolutely a legitimate disability. And that's why they kept appealing, because they just couldn't understand why the insurance company wouldn't see what was obvious to all of this person's treating doctors. It was an objective injury, and not only was it an objective injury, it was one that was visible with the naked eye. I'm not going to talk any further about what it was, but it was so ridiculous that the insurance company kept refusing it that they just kept appealing, because they just assumed that they weren't getting it. That's not the case. It's not that the insurance company isn't getting it. They get it. They just don't want to pay.
I mentioned a bunch of different ways so far you can reach out to James and his team, and I did mention mydisabilityquestions.com, which is exactly where we're going to go right now. James, this one, first one from Brienne. Brienne says, what is the biggest misunderstanding people have about the legal process and filing a claim against an insurance company after a long-term disability claim denial?
Well, the biggest misunderstanding people have is the extent to which they're going to have to be involved in the process. I think most people believe that, okay, if I start a legal claim, all of a sudden my entire life is going to change, and I'm going to have to be heavily involved in this process, and I'm not going to have control over my life. I'm going to have to filter all of my decisions through the fact that I'm in this litigation. And that's actually the exact opposite of what happens. When you start a legal claim, when you hire my firm to represent, from that point forward, there's no communication between you and the insurance company. So that's the biggest change right off the bat. You're not dealing with the insurance company at all. And the reality is, from the time that a client signs up until the time of mediation, there's very little that the client has to do in the litigation. Really, the only thing they have to do is at the outset, they have to give us information and sign authorizations that allow us to get all the information for our clients. We don't have our clients running around getting documents for us. We do that. And then they can focus on the rehabilitation and treatment right up until the mediation. And at the mediation, they don't have to say anything. They don't have to talk about their story. I do that for them. I'm the one that gives my clients a voice at the mediation. All my client has to do is be prepared for what's going to happen in the negotiations. And that preparation happens about a week before the mediation. I spend an hour or 2 with my clients making sure that they understand not only what their case is worth and what they should expect in the negotiation, but what they should expect to see at the mediation, what it's going to look like, how the day is likely to proceed. So my clients are very well prepared by the time the mediation happens. But their actual involvement in the process is very, very minimal. And in terms of their decision making, I always tell the same thing to my clients. I always tell them that they are in charge of what happens in their case and in their lives, and that all of their decisions should be made with that in mind. So if they start a legal claim and they get better, as my client I talked about at the top of the show did, and they're ready to go back to work, then they should do that, because they're much better off if they're able to go back to work than they are trying to continue to get benefits from the insurer. And all that happens in that scenario is that we would still proceed with pursuing what benefits they were owed from the time that their benefits were cut off until the time they went back to work. But their life is not going to change. They're not going to have to all of a sudden give up the control over their decision making because they've started a lawsuit. That doesn't happen.
Got to take a short break, James. Still got a few minutes to go, so stick around for it. Lots more Disability Law Show is on the way. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca.
All right, welcome back. Disability Law Show. Want to quickly get to an email, James, here in the last few minutes of the show. help@disabilityrights.ca is how you send one along to James or anybody in the team. This will be Katrina this time. Says, I fell last year and got a really bad concussion. I'm being treated at a concussion clinic and seeing a psychiatrist who has diagnosed me with depression and PTSD. I can't concentrate on anything for more than 10 minutes, and I have severe migraines. My insurance company denied my long-term disability benefits claim. Should I gather my documents and start the appeal process?
Yeah, so I'm not going to repeat the rant I just went on 5 minutes ago in the last segment. Suffice it to say, my advice is almost certainly going to be don't appeal. Now, the only question that I have for Katrina here, though, is did she provide those documents in the first place? If the insurance company doesn't have those documents, the foundational documents that show her disability, then yeah, you should provide those to the insurance company, because if they don't have them, then they're quite justified in not approving your benefit. That makes some sense. But if they already have the documentation that shows that you have depression, that you had a concussion, that you're suffering from PTSD, going back and providing more of the same isn't going to do anything. That's not going to move the needle at all. Remember, the insurance company is invested in finding a way to cut off your benefits. So if they found that justification, giving them more of the same is not going to change that. All it's going to do is make you run around in circles and not get anywhere. So no, if they already have that information, you know, a more emphatic letter from your doctor isn't going to change that scenario.
Can they turn around and say, okay, well, then we'd like to see one of our doctors, if you would? Can they make you do that?
Sure. I mean, that's something that happens from time to time. Typically speaking, if the insurance company has already made the decision that they're going to cut off your benefits or deny your benefits, they're not then also going to send you for an assessment, but oftentimes within the process that will happen. Now, if you haven't seen a specialist yourself, if you're in a situation where you have a disability and you're treated by your family doctor and they're denying your claim on that basis, it can be beneficial to get a referral to a specialist if that is the basis that the insurance company is denying on. It shouldn't matter. It should be that your family doctor's opinion is enough to satisfy the insurer, but oftentimes it won't be. So if they specifically say, listen, you know, your family doctor says this, but you haven't been referred to a specialist, we don't have an opinion from a specialist, we need to know that before we can approve. If they've specifically told you that, then yeah, it's worthwhile getting a referral in that scenario.
There's all kinds of information to be had every week here on the show. James, appreciate all of it. And if you want to ask James about appeals anytime, I know he's willing to have that chat. The phone number, 1-855-821-5900. Email help@disabilityrights.ca. We'll catch you next time.
If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed.